For your legal consideration. Many people over years have been legally cheated out of justice by the police and the Crown Prosecution Service. The following is a summary of just how they do it. Defendants are illegally presented before judges and juries appearing as criminals in prison uniforms with cuffs on before the case is heard by the court. This will give the judges and juries the impression of guilt instead of the impression that should be set of being innocent until proven guilty. During a court case, the prosecution service presents their case first. The law states innocent until proven guilty. Therefore, the first presentation and first impression of the defendant should be set by the defense barristers. The positioning of parties in the court is wrong. The defendant should be on the right of the judge and closest to the jury. In reality, it is the opposite setting and the wrong impression on a visual level. A defendant's character is assassinated by the prosecution service with police and witness statements. As a standard practice, shouldn't the defendant's solicitor and barrister be given full access to police standards departments and IPCC's information about the characters of those testifying against the defendant? Judges spend a lot of their personal time being surrounded by police overacting as security. I believe this is a form of conditioning that could inadvertently affect the balance of justice. Security for judges should only be provided by personnel independent of police and the prosecution services. Prior to the events of 9/11, the FBI was stood down from further aggravating of terrorist suspects by USA's military intelligence from. The FBI had the stand down overturned by their favorite condition judge, the equivalent of a British High Court judge. The judge wrongly ruled that FBI intelligence was better than that of USA military. Later, as we all know the story, the FBI was waiting for the suspects in the underground car park, waiting for the terrorists to drive a fertilizer bomb under the Twin Towers. The police can and do cheat some people out of a competent judicial ruling by accusing a suspect of being mentally ill. Section 2 of the Mental Health Act. A direct transfer of a suspect to a psychiatric ward for assessment forgoes justice in a competent court. Federal police collectives in this country breach the rights, international human rights law of citizens, residents and tourists every day by quoting questionable national security law that states that national security suspects have no rights. They forego proving a person guilty and go straight for punishing the suspect personally, something they are not allowed to do to a person convicted of a crime. My question that will go unanswered is how many terrorist actions were started by thick 9/11 type federal police instigating the violence by breaching people's human rights. After a national security suspect has undergone human rights abuse and been cleared of wrongdoing, there is a questionable non-disclosure of what has transpired to the suspect. Is that the federal police's method of keeping their jobs, repeating their sadistic mistakes and stopping their government departments from being sued for stupidity and breaching international laws on human rights? What happened to innocent until proven guilty? A charged person's previous record is always presented by the prosecution in order to convince a judge or jury of a person's current guilt. This is the crooked tricks of the prosecution service at work again. The only place in a criminal trial for this presentation is after prosecution is successful and during sentencing. A judge that signs for warrants shouldn't be allowed to preside over that same case for the same reasons that juries should have no prior connection with the defendant. The presenting of classified information to a judge by federal police must be rebutted by internal affairs type departments and highly qualified defendants, barrister, solicitor, otherwise the judgment will be unbalanced, favoring the prosecution over the defendant's right of a fair trial. The defendant should have the right to face his or her accuser. The defendant's barrister should have the right to cross-examine all witnesses with information from the defendant about the witness. Hearsay information given by police about what their informant said should not be admissible in any court. Yet is. They present it as classified criminal intelligence some of the time. There should be a clarification by the presiding judge of any interference, such as antagonisms toward the defendant, prior and during a trial that may disadvantage the defense. There should be a clarification by the presiding judge of any interference, such as spying or sabotage on the defendant's legal team that may disadvantage the defense. The Crown Prosecution Service should clarify all information and sources to the defendant's legal team so as leaks, spying and sabotage can be judicially prosecuted for contempt of court. Using courts to legally gag the failings of the federal police to the media is illegal. All are equal before the law, including federal police. If the truth of the failings of the federal police is a threat to national security, what does this tell us about the nation and the federal police? Nicotine withdrawals faced by defendants brought straight from a smoke-free police lockup to a court will unfairly display the defendant as being abnormally anxious and easily aggravated, thereby wrongly swaying a judge or jury. Withdrawal from other drugs will have a similar effect on the judge or jury. All crimes that a suspect is charged with after their human rights are violated by federal police hiding behind nation security laws should be identified as being entrapment. My position is that the suspects would have been internationally illegally forced into a fight-or-flight psychological disposition that is abnormal to them, after which they would have committed a crime such as violence or theft that is out of character but not out of context of the situation they were internationally illegally forced into. After a suspect's human rights are breached, no subsequent confession in or out of court or the media is admissible or legal. Evidence tampering has precedence. Therefore, how can any evidence be beyond a reasonable doubt? The evidence of Azaria Chamberlain's blood was entered into evidence in Australia's biggest ever murder case. When the evidence was re-examined 3 years after the travesty of justice in the prosecution of Azaria's parents, it was revealed as red rust from the front seat passenger's floor pan with normal skin flakes of someone from the Chamberlain family. In today's day of wireless networks everywhere, how can anyone be charged with computer crimes unless they admit to it? After all, big banks in the UK were compromised for some time by modified Wi-Fi devices attached to their internal network masking themselves as wired devices. For someone to be successfully charged, traditional evidence tampering resistant film cameras would have to record every keystroke of hacking code. British federal police are in the habit of employing foreign federal police sworn to different foreign secrecy acts. This, I believe, is illegal. Certain countries, unnamed here, commit illegal actions and report falsely with laced foreign agendas that are incompatible with local laws as well as a suspect's legal rights. Interference with correspondence can cause a defendant legal damage. On 2 occasions, once in Australia and once in England, I have received an on-the-spot fine. On the fine is a section to fill out if I desired to challenge the fine in court and where to send it. The police would then organize the court hearing without notifying me. The cases were heard by the courts without my or my legal counsel's presence. However, I did get a letter in the mail designating how much I had to pay, where I had to pay and by what date. When I was cheated out of my day in court. I believe this to be a common scam of the police to cheat others out of justice.